my name is Rafael Villera and I'm partnered at Celier Abogados. And today I would like to talk to you about the awaited judgment issued by the European Court of Justice regarding the reporting obligation of the Spanish tax code, commonly known as Form 720. By means, as everybody knows, by means of Form 720, it's in force since 2013, Spanish tax residents having overseas assets are obliged to disclose on a yearly basis their assets abroad. Specifically, the assets to be reported to the tax authority on a yearly basis within the first quarter of the following year are the bank account in financial entities abroad, the securities representing equity or debt which are deposited abroad, and also the real estate and the rights on real estate that are located abroad. At this point, the persons obliged to file the Form 720 are the title holders or the ultimate beneficial owner of the assets according to the anti-laundering legislation. But for the bank accounts, also the persons having the right to dispose of the money deposited in the bank account are also obliged to report said right. At this point, it's important to say that the judgment does not declare illegal the reporting obligation itself. In other words, the Form 720 is not illegal and must be filed within the deadline, which for this year is 21st March 2022, regarding the assets held during 2021. Once said that, what it has been declared illegal by the European Court of Justice is the penalty system around the Form 720, as well as the capacity of the tax authority to charge taxes on income earned in a barred period for tax purposes, thanks to the legislation around the Form 720. In that regard, it's important to say that the Form 720 has its own penalty system, consisting in a fine of 5,000 euros per data or set of data that has not been declared, or which has been declared with false data or with non-accurate data. In addition to this penalty system, the tax authority also amended Article 39 of the Personal Income Tax regarding the unjustified capital gains, and the corresponding article in the corporate income tax, the Article 121. The amendment consisted in the addition of another paragraph by means of which the assets which were not declared in the Form 720 or which were declared and inaccurately are deemed unjustified capital gains of the last fiscal year, which is open to tax audit. And therefore what it means is the tax authority, it has the capacity to charge taxes on income which was earned in a barred fiscal year. In addition, the General Tax Code was also modified to include an additional infringement consisting in 100% penalty, in a penalty calculated as 150% of the tax due resulting from the unjustified capital gains that we recently talked about. The judgments rule illegal the penalty system described before, but as said, it does not declare illegal the reporting obligation of Form 720 itself. Therefore, this year, 2022, taxpayers are still obliged to file the form within its deadline that ends next 31st March. However, the Commission in 2015 already warned the Spanish tax authority regarding the legality of the penalty system described. Later, in 2017, they issued a recent opinion that received an inadequate answer from the Spanish tax authority, leading to the lodge of appeal with the European Court of Justice that resulted in this judgment. Specifically, the European Court of Justice declared illegal, because it is contrary to the free movement of capital, the following aspects of the legislation around the Form 720. The first things that declare illegal is the capacity of the Spanish tax authority to charge taxes on income earned in a barred period. Also declare contrary to the free movement of capital the penalty of 150% of the tax due resulting from the unjustified capital gain of the assets non-declared. And finally, also declare illegal, and because it is contrary to the free movement of capital, the specific penalty system of the Form 720. Therefore, to this day, this penalty system must be considered void and null, and therefore it has no effects at all. Consequently, those who had been already punished with those penalties and have received reassessments for the unjustified capital gains resulting from the undeclared assets, they can claim the refund of those unduly taxes and penalties from the Spanish tax authorities. On the other hand, those taxpayers who already have concealed assets to the Spanish tax authority, they have now the opportunity to disclose those assets at a very low cost in terms of taxes. In Celiar Abogados, we are at your disposal for any further question you may have regarding this judgment that applies to your specific case, and also to file any writing requesting the refund of the unduly paid taxes and penalties, as well as to assist you to disclose any concealed asset that you may have. So please feel free to call us.